You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And David, thanks for joining us again from your home. Here.
And yours.
Yeah.
It's good. I'm looking forward to today.
Well, yeah, we've got we got a really cool thing to talk about, stare decisis, and I'll give my little encyclopedia definition I found for that here in just a minute. But I know last week we started, and I kind of wanted to start a thing. Last week I did a dumb tweet of the week, which was fun. But this week, instead of doing a dumb tweet, I found this clip. And this is a pastor from a church in Sioux City, Iowa, I believe, and he's doing one of those parking lot services. He's standing outside, and so go ahead and take a listen.
It's too late for the economy. It's too late for tens of thousands of businesses because you wouldn't obey God's law and you wouldn't obey the Constitution. People are being harmed all over the world. And that modeling that brought you global cooling and global warming, and then we had to flatten the curve, now they're whipping it out and saying, oh my goodness, we may cause a worldwide famine with how we've responded. Big duh. You think if you had obeyed God, we wouldn't have to worry about children in Africa dying because they have no food. Because you Christians, you evangelicals, you ignore the law of God every time you vote. You keep putting stupid people in office. And what do they do to us? They ruin the nation. They shred up the Constitution. And I'm talking to my friends. You don't listen. Exodus 18:21. Read it. Put it on your refrigerator door. Memorize it. 4 things. If they don't meet the requirements, don't vote for them. Your lawlessness caused all of this.
So that was some pretty strong stuff there. He mad.
He was. I think I could hear him, and he was very angry. And if you can filter out the tenor of what he said, there's a lot of truth in what he said.
Well, yeah, I thought so. I looked up. He mentioned these 4 things in Exodus chapter 18, verse 21. He said, and here's what it says: "But you should select from all the people able men, so people that know what they're doing, God-fearing, trustworthy, and hating bribes. Place them over the people as commanders of thousands, hundreds, fifties, and tens." And, he's right. We've completely lost that filter on people that we vote for today. And we're discussing an issue today. And part of the issue of stare decisis is men and women that we're sending to Washington, D.C., that are appointing judges. And at the end of the day, none of them have any idea how to uphold the laws of the Constitution, and we shred the thing every day. So it's a problem.
Yeah, we really do.
It's our fault. We did this to ourselves.
Sadly, as I mentioned before we got on today, most of the races for the General Assembly are uncontested, so we don't have any choices. And
so what
we
you
really
got?
need some. Yeah, so we really need some godly men and women who are willing to train themselves in the principles of law and policy according to biblical principles and constitutional principles and run for office.
Absolutely. Amen to that.
We need that.
Well, I think it's
and
appropriate.
Today, as you said, we're going to be talking about another subject that most legislators will say, yeah, I know about stare decisis, and they don't. They don't have a clue about it.
Well, in light of everything we just said, I think it's appropriate to open up with this quote from Alexis de Tocqueville, which I believe we started the podcast with, if I remember right. And
I think we did,
and we've gone back to it several times. And it says this: "If the lights that guide us ever go out, they will fade little by little, as if to their own accord. Confining ourselves to practice, we may lose sight of basic principles. And when these have been entirely forgotten, we may apply the methods derived from them badly. We might be left without the capacity to invent new methods and only be able to make a clumsy and unintelligent use of wise procedures no longer understood. That is prophetic.
And that's what we're going to be talking about today. Yeah.
So David, stare decisis. So I pulled up I Googled stare decisis. That's what I do. School of Google. And
School of Google.
Came up with this is a definition. I found it on a Cornell law website, and this definition actually came from a Supreme Court case where they had sort of given it this definition here. Quote, stare decisis promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. That sounds nice. But does it really? And
there are elements of truth to that, but one of the things.
Can you give us a really quick what is how should the lay person know what stare decisis is? What do we mean when we say that?
Well, there's actually a Latin expression, and I don't have it. I ran into it today, but it means let the thing decided.
To stand by things decided. Yep.
Yeah, that's right. Let the thing decided stand.
I Googled that too.
Yeah, and so the point is, and this really is important, we need to have stability in the law. That's why the rule of law is so important. It's because what you find in tyrannical countries, despotic countries, is that the law changes with the whims of whoever's got the biggest gun or whoever's in charge. And so you can't plan. You can't know how to predict or how to behave, because what you do today may tomorrow be illegal. And we've seen a lot of this with COVID. How do I really plan anything? How do I know how long this is going to last, and so on and so forth. So it is important that we not just willy-nilly reverse a case, but we shouldn't be keeping decisions, matters that are decided when they're clearly wrong. And one of the things we first need to do is, as we've been talking so much about the Rule of Law Life Act over time, and Roe versus Wade, and Planned Parenthood versus Casey, and stare decisis, and how do we ever get over these precedents? And they've been out here so long, and we just can't get there. And then we had Obergefell, and the court just ruled that way, and so they're not going to change their mind. Well, let me just tell you that it's not as sacrosanct as some people think it is. And every current justice has voted in the last 5 years to reverse a long-standing precedent. All of them have been in the majority to do that. And to add to that, they've dissented when we haven't reversed a precedent. Okay, so they're all willing to do it. It's not like
even oftentimes whenever they've upheld a precedent, there's been a dissent written on how bad the precedent actually is and why they should have changed it. Yeah,
that's right. That's right. So this isn't like, son, I remember one time in my life they reversed a precedent at 60 years old. I remember I was 9 years old and my daddy came in and said, son, you need to hear about this because it's not going to happen again in your lifetime. Yeah. No. In 2019, they reversed two precedents from the 1970s. In 2016, they reversed precedents. They reversed at least one. In 2015, they reversed two. In 2013, they reversed one. So they're reversing precedent off and on all the time.
And we reversed a pretty big one last week, didn't we?
Well, we did. We reversed one that was 70 or 80 years old, Ramos versus Louisiana. Yeah. And then we reversed one last year, Nick versus the township of something, and it was from 1979. And of course, we reversed the in 2015 with Obergefell, we reversed a decision from 1972. So that's 43 years later. So even the current court has been reversing precedent. And one of the things that I think people need to appreciate is that we now have on record, I was going back through it today, I have a little piece of cheat sheet here. Justice Gorsuch reversed precedent in the case that came out, a week ago, maybe 10 days ago, in Ramos versus Louisiana. We talked about it. Kavanaugh.
That was a 1972 decision, by the way. Yeah.
Okay. And Kavanaugh.
Apodaca versus Oregon or something like that.
Right. Kavanaugh wrote a long concurring opinion where he went on and on about stare decisis. And one of the things that he said is, he says, we don't have a consistent way for looking at stare decisis, and it's left a muddle. And it doesn't appear that we apply it in any kind of neutral or consistent manner. And there's actually a dissenting opinion, I think, from Thomas. He says, stare decisis means we uphold what we want and we don't what we don't.
See, that's the problem.
It's arbitrary.
That's how it ends up being used. It's not a consistent application of,
sure.
Because that's the argument of what it is. Well, we have it to make the law consistent, but really you nailed it. I mean, we really just use it whenever it fits our argument. We use
That's right.
it.
That's right. When it fits our case. Then Alito last year wrote a long opinion, Gamble versus U.S. He was the majority author of that opinion. They did not reverse a precedent that was 120, 170 years old, but they had a long discussion, Alito did, of what's required to reverse precedent. Roberts was actually the writer of the opinion in the Nick case last year that reversed precedent. And then they recently reversed another one, Franchise Tax Board, that reversed a longstanding precedent. And Thomas, I think, wrote that opinion. And the interesting thing about that case, which we've not talked about and we won't get into, but they said part of the reason that case was wrong is it violated the concept of dual sovereignty in our state-federal structure. We got it wrong. And so when our decisions upset the balance of power between the states and the federal government, we should reverse. And they did. And that's the problem with abortion. That's the problem with marriage. Is it's changed.
You mean like when the court says that a state can't make laws regarding protecting
a marriage and abortion, right?
Yeah.
And they can't even regulate doctors' practices within their own state. Mm. So all these to me are encouraging signs. But the point that I want us to discuss today is a little bit the misunderstanding of why we have stare decisis. Where did it come from? What originated it? And to what extent does it really even apply today? And it's one of those situations where we've done something for so long that we think we need to keep doing it, and we just keep repeating things. And to throw in a little humor here, it's probably very little, but the old story goes of a young bride who was getting ready to make the Easter ham or something, and she cut it in half and put it in the pan, and her little daughter said, "Mom, why do we always cut the ham in half?" And she said, "I don't know. Just my mother always cut the ham in half." And she said, "Okay." So she called her mom and said, "Mom, why did we cut the pan in half?" And she said, I really don't know. Just my mom always did it. Your grandmother did. So she called her grandmother and she said, why do we cut the ham in half? How does that help the ham taste better? And she said, "Well, it has nothing to do with cooking." She said, "I just didn't have a pan big enough to put the ham in." It's kind of like, oh, so this has nothing to do with cooking a good ham. It's like, no, I just didn't have a big enough pan, and your mother just assumed that that's why it had something to do with the cooking method, but it didn't. And so if people want to today, let me encourage them to go back and listen to Adam McLeod talk about common law, because the idea of
it's episode 18. If anyone wants to look
okay,
that up.
Okay, episode 18. You need to listen to it again, or if you haven't listened to it, listen to it. But we talk about England having a constitution, but they don't have a constitution like we do. Their constitution is made up of court decisions. And so when you understand the common law, the idea was, and there's a great opinion where Clarence Thomas the more I read of that man's writings, the more I think he just needs to be a one-person Supreme Court, to be honest. But he said the idea of common law was that the judges were trying to discern from history and tradition what the basic principles were upon which that history and tradition had developed in order to then apply them to a new situation. And so what the idea was is the judge doesn't create the law, he finds the law. The law is outside of ourselves.
Similar situations.
It's outside of ourselves, which is rooted in the notion of natural law and of course, the whole concept of a transcendent God that's outside of that declares law and so on and so forth. But the idea is that we begin to distill and discern certain principles, and so now we've distilled and discerned these principles. Now we have a new case that comes up, and how do those principles that brought us to this place, now how do they apply over here?
Right.
But you were always going back to the fundamental underlying principle before you extended it. And sometimes they would say the judge actually mistakes the law. And the concept there, I didn't get the principle right. Or I misunderstood how to extend the principle because I didn't really understand the principle right. So I need to reverse the case and get the principle right. But the point was, because all the, quote, law was not found in the cases, it was evidenced by the cases, and that's an important thing. Today, you and I go find the law. We go get those green books in the library, Tennessee Code, and we read the law. And they said, well, the law is out there. Our opinions are evidence of what that law is, and we may get it wrong. And so we would reverse those opinions. But once we've decided something, for the sake of stability, for the sake of prediction and being able to order our lives appropriately, we ought not to reverse those decisions lightly, you see. And so that's where the concept of stare decisis came from.
Which made sense when your entire law rested upon those judgments being made in the courts, which England still rests on those today. I mean, today in the UK, they still don't have a constitution. They rest on that common law that's been established through centuries now.
That's right. That's essentially their constitution. They haven't written it down. But the point was that the cases, this is important for people to understand, the cases didn't make the law. They declared what the law was. It was evidence of the law, because I might be wrong, you see. It was evidence of the law. So for instance, let me apply that. With our Common Law Marriage Recording Act, the common law said that a man and a woman who made a commitment to each other, it was the Latin phrase meant words of the present moment and intention. I take you, Linda. Linda takes me, David. That constituted the marriage. Now, what I would do is I might go down to the courthouse and I would record a document. But the document didn't make me married. It was evidence that I had gotten married. So that 10 or 15 years later, when I die, Linda's not left trying to prove we were actually married and she's entitled to inherit or something else. So, and we actually have a Supreme Court case on that says, the United States Supreme Court, common law marriage was a right that every man and a woman had a right to do. The statutes were created to give evidence that it had happened. So that's what precedents were, is they were the law as to those parties, and they were evidence of what they thought the law was, but we may now find that it's wrong. So let me give you an example. In the common law, we heard Adam talk about, we came down to the idea that there are three absolute common law rights: life, liberty, and property. Life, liberty, and property. They found their way into the Due Process Clause. No person, it's not any citizen, but no person should be deprived of life, liberty, or property without due process of law. Why? Because every person has those rights from God. not because they're a
worth
citizen.
noting on that point that whenever we put those things in the Fifth and the 14th Amendment, we didn't just make that up. That came from our common law.
That's right, and they had an understanding at common law. So let's say you have a common law judge. We have those written statutes, and somebody says, "Well, I think I have a right to have an abortion." The judge says, "Well, we like liberty, so we're going to interpret the word liberty to mean you can go hire a doctor and have an abortion." And that's what we think the law is. That's the extension of the concept of liberty. Well, along comes another judge and he says, wait a minute. There are 3 absolute rights here, and one of those is to life. And you just expanded liberty to such a point that it actually takes away another person's life. That can't be wrong. That case is not evidence of what the law really is. It's wrong. We need to reverse it. You see. Now, what Clarence Thomas points out is that America, the United States, chose, while we are a common law nation, except for, your home state of Louisiana, we're common law states. We're essentially a common law-based nation, which we took over from England. But we decided to write our Constitution down. There was a great statement from Thomas Jefferson, who really did not like the common law. He said, we need to bind men down in the chains of a written constitution, so that when we use the word person, everybody knows what a person is. We're not going to have some,
what that means, right?
Yeah, we're not going to have some judge giving some strange interpretation to the word person. We all know what a person is. And we're going to tie him down with life and liberty because we all know what that is. And so we're going to write those things down so some judge doesn't go off the ranch, okay? And so we have a written constitution. Now, that written constitution is said, by virtue of the Constitution, the supreme law, right? That's the supreme law. What Clarence Thomas points out so well is he says, when we are in a different system than the common law system. And let me see here if I can find the statement that he made. He said, federal courts look to different sources of law when exercising their judicial power than did the common law courts of England. See, they were interpreting positive laws, the federal courts are. We wrote this down on a piece of paper. What do these words mean? We're not trying to discern vague principles and distill them out of long history, custom, and tradition. We wrote the word down. So when we get the word wrong, we need to say the Constitution's word was interpreted wrongly. The Constitution is supreme, not the court opinion. So to heck with stare decisis. He said it really doesn't apply in our system because our system is based on statutes, the Constitution, and treaties. And he says, so when the law needs to develop, and here's the point. If we said liberty means only to not be constrained in my body in locomotion, the ability to move about, and we think, well, no, wait a minute, that really doesn't help me have an abortion. Well, what Clarence Thomas says is, it's not our job to rewrite and reinterpret what liberty meant. If we don't like that word, if we think that it needs expanding, we do that through the political process in our country, not through judges.
Right.
They're not developing the law in the way that the courts of England developed the law. They were developing the law. That's how the law developed.
According to how our constitutional branches are supposed to work, the court doesn't have the ability to expound upon or expand what's written. If what's written needs to be expanded, well, then the Congress needs to form a new statute, or we need to amend the Constitution.
Absolutely. And so what's happened is that's why, these people that have a living Constitution view, they love that concept.
Yeah. Because
now we're not rooted to any particular words or any particular meanings. And I get their point. Well, this could be really frustrating, David, because we might have to amend the Constitution next week, and then we might have to amend it the next week.
It's supposed to be.
Well, it is. But here's the thing.
That's what keeps us safe from tyranny.
Well, but here is the thing. The legislative bodies can express the will of the people. And in fact, in this law review article I've been writing, the Supreme Court of the United States said, look, the powers of the federal government, now they're talking generally here, were generally worded. We didn't want a constitution that says you have a right to comb your hair, you have a right to change your clothes, you have a right to take a bath, you have a right to blah, blah, blah. We laid out general principles, and Congress, it said, could mold its powers in such a way and exercise them as to keep things contemporaneous. You see what I'm saying? So in other words, if we need to have a greater understanding of liberty, we say, oh gosh, people are cracking down. You can't brush your teeth anymore. Let's pass a statute that says everybody has the right to brush their teeth. You see?
Yeah, Congress, through the authority of the people that voted them there, can expound and expand those things within statutes. Yeah,
that's right. Now, we need to keep in mind, I've used the bad example of brushing teeth. Congress can only act in areas that were designated. It's a government of limited, not common law powers. So it would have to, going back to my toothbrushing example, they'd have to find somehow that brushing teeth had an impact on interstate commerce, and that's why we can, regulate toothbrushing. But Congress has limited powers, and the rest of the powers were left to the states. And see, that's what's happened through the 14th Amendment, is the court has been eroding the powers that were left to the states, eroding, and saying, you can't do this, and you can't do this, and you can't do this, and essentially rewriting the Constitution. And then they rely on stare decisis for why they can't change it back. You see, the regulation of the health industry in healthcare, the Supreme Court, I've got a case very early on, and all these are famous cases every law student reads, but I think it's Martin versus Hunter's lessee. It says, look, the states are to regulate health within their own borders. That's one of their functions, and they do that best because they're closest to the people whose health needs to be regulated. And Congress doesn't have any power to do that, and we should butt out. So when the state passes a law to regulate the practice of medicine, to say we don't want doctors being paid to kill natural persons, our founders would have said, well, of course they can pass that law, because that whole field of law is committed to the states. There's nothing in the Constitution about the federal government regulating the practice of medicine in the state of Tennessee or the state of New York. But see, so the Supreme Court usurps our authority, and then our state legislators, because they don't understand the concept of common law, they don't understand stare decisis, they don't understand the Constitution, they don't know what they're doing. Let's just put it.
Yeah, that goes back to our nice friendly pastor we played at the beginning.
That's right, and I'm going to try not to get as friendly as he was. They bow down to the Supreme Court as if there's nothing we can do, and they rewrote the Constitution. Those people who think that way need to be removed from office, and I don't care who they are, and I don't care how many times they go to church, I don't care if they do a Sunday school class, they are not able men.
Right.
Not for what they're charged to do.
They're not Exodus 18:21 men. Hey, so let me ask you this. So we get that stare decisis, this idea of precedent was how, common law came together. And of course and of course we do use it today. It is a good thing to provide consistency in law, and
that's right.
And it is good for the court to be consistent in how it makes its judgments. So I get all of that. But how would you say, kind of moving into this next area, how would you say what does it look like to appropriately apply stare decisis in this constitutional republic that we have now? How do we juxtapose this idea of looking back at precedent and providing consistency through precedent while also making the Constitution supreme in those rulings?
Yeah. I'll this is the way Thomas wrote his opinion in the Gamble case, which affirmed a hotly contested precedent that was well over 100 years old. I can't remember, but well over 100 years. And he said, look, here's the burden that you have. When we've made a decision, you need to show that it's erroneous. Okay, that we overlooked something, we forgot something. Maybe we got our history wrong. Maybe we overlooked a part of history that's now been discovered. And that may sound strange, but we're always discovering new things about our history, things that we didn't know. We found a new letter from so-and-so or from Thomas Jefferson, or we uncovered, some other thing that gives us better insight into what these words mean. And he says, so your burden, once we've made a decision, is to show why we're wrong. Okay? Now, if you can't meet that burden in a convincing way, not, well, gosh, we got the same evidence in front of us last time, the same legal precepts, and maybe we might draw a different conclusion than the people did 100 years ago, but we can't really say that they were wrong because there is evidence for that conclusion. So we're going to leave it. We're going to leave it alone because stability is important. But Clarence Thomas says this, but if we see that we were wrong, that we got our history wrong, that our analysis was wrong, that we overlooked fundamental precepts and concepts that we just flat didn't consider or considered incorrectly, he says, then we're bound oath-wise, as a matter of duty, to reverse the precedent, whether it's a year old, in the case of Obergefell, 5 years old, or in the case of Roe versus Wade, 46 years old, 47 years old. Because here's what he says. If you affirm the precedent that's clearly erroneous, it elevates demonstrably, he says, the opinions of the court over the text of the Constitution. And see, we've decided, because we're a positive law constitution, we're not a court-developed constitution. The text of the Constitution is controlling.
Should always be.
Always. And so when we find out that we're wrong, don't get into this, well, how many people have relied on it over the years?
Who cares?
Who cares? The Constitution is the supreme law. And that's where Clarence Thomas really gets on his colleagues, is you're wanting to go over here and you put all these factors in. And then here's the thing. This is what Kavanaugh was complaining about. We've really never articulated these factors very well, and all of them can be manipulated.
Yeah.
Now let me give you an example of manipulation. In the Casey case on abortion in 1992, the court said, well, gosh, this has been the precedent for like 19 years. People have ordered their lives, redefined their views of themselves. I mean, it would mess up people's careers. There's so much reliance on this. It doesn't matter whether it's really right or wrong anymore.
I think that is the worst statement ever made in a Supreme Court case. We can't change this horrible ruling only because too many people rely on it now.
That's right. That's right. But then here's what they do. Let's come up with Obergefell that's 5 years old. What they'll say then is, well, gosh, if we reverse a 5-year-old precedent, the law's not stable. People need to be able to predict things. Why don't you wait 20 years and then we'll have stability in the law and we can reverse it. Oh, I'm sorry, we can't reverse it 20 years from now because now everybody's come to rely on it. You see why it is a farce. It is easily manipulated to say, well, we got this decision wrong last year. We better reverse it. No, we can't do that. We can't do that. That'll look like we're just flip-flopping.
Let's wait so that we make the law stable. Oh, but then we waited too long.
Yeah, now we waited too long. So I don't know when is the right time to reverse. And what Clarence Thomas says, when we know that we're wrong, reverse
it.
Period. Because our duty, our obligation, our oath is to the Constitution and the text, not to the court's opinions. And that's where I get so angry and frustrated with these people who bow down to precedent and come up with these graduated abortion bills, going to the court to say, can I ban abortion at 6 days, 8 days, 2 weeks, 14 weeks, 12 weeks, 16 weeks, 17 weeks, 18 weeks, 19 weeks, how about 20 weeks, 21, 23, 24?
Stupid.
Yes, it is. And I want to say, you need to go to the court. When everybody is saying the court was wrong, then give them a case, give them a statute that allows them to say, we were wrong. You've given us something new to think about. This is the problem with the abortion bill that's been proposed and already passed through the Senate committee, is that they're relying on the same precedents that they're held captive by.
But the funny thing is they're relying on precedents of bills that have all been struck down by the court. Why would you want to rely on that precedent?
Well, I don't know, but see, they're arguing the case within the precedent of Casey and Roe.
I see what you're saying. Of those decisions, yeah.
Yeah, as if they are the Constitution.
Yeah.
And what we've tried to do with the Rule of Law Act is say, look, because these guys on the Supreme Court go all over the place and they're unpredictable, we better give them something new to think about, something they've never had to look at, so that those who want to get it right will have an excuse for getting it right.
And narrow the focus so that they have to look at that one thing.
That's right. Now, if you remember back in the testimony in August of last year, when we were debating the abortion bill in front of the Senate Judiciary Committee, Jim Bopp said, predicting how many judges we're going to have is very hard. In 1992, when Casey was decided, we thought we had 7 justices on our side, and we got 4.
Well, in fact, he said we knew we had 7 justices on our side.
Yeah, we had good reason to believe we had 7.
Yeah, we
had good reason to believe we had 7. We got 4.
Yeah.
But you were arguing within the same context. That's why Clarence Thomas last year, when the Supreme Court voted unanimously to not hear the dismemberment abortion decision out of Alabama, Clarence Thomas said, I don't even want to hear this case. I've declared over and over and over, Roe versus Wade is wrong and Casey's wrong. But if you don't give me a case that puts it specifically at issue and gives me a chance to reconsider the issue and giving me something new to think about, I don't want to hear it.
Was that where he said distinguish away?
No, that was Scalia.
Oh,
but this was a case just from last year where I think it was the Fifth Circuit had said that the Alabama law that prohibited dismemberment abortions, which began at about 14 or 15 weeks, they said, well, it's unconstitutional. And they appealed to the United States Supreme Court. And it was unanimous. We don't want to hear the case. And Clarence Thomas wrote an opinion to say, here's why we don't want to hear it. He said, this is terrible, terrible law. But you didn't present the question to us. And if you're not going to give me the right question, I'm not interested in talking about it.
Right.
And unfortunately, the bill that's been proposed by the administration that the Senate committee just sent through to the Senate floor, it relies on all the very precedents as being acceptable that they want the court to reverse. And they've given them no new legal constitutional concepts to reconsider. Now,
we've given them
if the
the
bill
same
passes,
old,
I hope we win.
We've
But
given
you
them
bet,
the same
old thing.
arguments that federal courts across the country have, and appellate courts have already held unconstitutional.
Yeah. So anyway, that's what makes me sad. But really, if the people understood what stare decisis was and was not, and how to challenge it, how to get around it, what is necessary to get around it, we'd be a whole lot better off. But we don't.
Well,
we lack able people.
And what you said earlier too, what you pointed out, is that we have now 5 justices sitting on the bench that, at various points in time, have shown their hand that they sort of feel the same way about stare decisis, and that we've misappropriated it at times, and that we need to get back to what the law says, what the Constitution says. Right. So I think we're in a. Some say we're not. Some say it's too risky. Sure seems to me like we're in a pretty good season of the Supreme Court getting serious about applying the Constitution as supreme in its rulings.
Sure. And the case that just came down, we kind of can close with this. I guess we've gone, who knows, too long today. But the Ramos case that we started about, they spent a lot of time looking at the common law to determine what the right to a jury meant and whether it required the unanimous consent. That's right. They spent a ton of time on the common law. That's all it was about.
And quoted William Blackstone directly.
And called him the eminent, spokesman for the common law.
Yeah.
I mean, the judges are doing exactly what our legislation would ask them to do. And so when the statement was made last August in those committee hearings, that I've never heard such a silly thing as the common law trumps the U.S. Constitution. Fowler's crazy.
Oh, Jim Bob.
I'm not going to mention any names, but the point is the Supreme Court just reversed because they said this is what the common law clearly required, and that's what the Constitution means. And here we go. Boom, we're reversing.
Yeah.
It's not that the common law is superior to the Constitution, it's that the common law helps define the words in the Constitution. And we've refused to use them. Well,
I also think it's a great point too, the case from last week. I actually went back to the hearing and looked at some things, and there was a clip that we had pulled. The chairman, Mike Bell, had asked, this is whenever Adam McLeod was giving testimony, he asked Adam for, basically he was just ruminating questions in his head about, well, has the Supreme Court ever made decisions based on the Ninth Amendment? And he said, does common law still regularly inform their decisions today? And he said, yeah, gave some examples, whatever. But in light of, I looked at that clip again, and I thought, well, man, just last week you've got our Chief Justice of the Supreme Court, not Chief Justice, not Roberts, but you've got Gorsuch, quoting William Blackstone's commentaries and talking about the common law in light of what does the Constitution mean. I'm encouraged, by where there's a lot of crazy stuff going on, but I'm really encouraged by what the Supreme Court has done recently, and how, and I agree with you. If we could just have Clarence Thomas on the Supreme Court, that would be
we just need some phenomenal. Able men in the General Assembly.
God-fearing.
And I'm not using that in a gender-specific way, but who understand what we're talking about and are willing to give the justices what they need to reverse.
Yeah.
And
you can do it, Tennessee.
Yeah. You can do it.
You can do it.
Yeah, let's lead the way. And actually, I got contacted the other day by somebody in the Arkansas General Assembly who's interested in the Rule of Law Life Act. So I'm hoping it'll spread to other states, even if our guys don't get it. Maybe somebody in Arkansas will get it.
Fantastic.
We can hope.
Hey, thanks for joining us again, everyone, on our podcast. And we hope you're enjoying these discussions. And if you are, I would encourage you, please share this with your family and friends. These are just really critical. These are critical discussions, and they're discussions definitely not being had to a great degree in mainstream. And so we depend on you and like-minded folks to share the message. As always, you can send an email to info@factin.org. We'd love to hear your comments, questions, and would love to be able to address some of those on our show. And thanks again, David, for your wisdom here. And it was a great conversation on stare decisis. And
see everybody next week.
Yeah, see you next time.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's facttennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.